afternoon. I'm Chris Rickard. I'm a policy counsel with the ACLU's National Political Advocacy Department, and I am based in Houston now, so it's great to be part of this. Really would like to thank CMS and our Houston hosts as well. It's been terrific so far, and I've gotten a lot out of it. And I'm very proud to be moderating this panel because we have an excellent trio who I think you'll see represent very different aspects of our topic today. And I wanted to introduce them, but first remind you that there's CLE credit. So if you're a Texas bar member, do sign up at the table outside. And I just wanted to say a bit about my perspective too, because I think I'm the least lawyerly of the four people in front of you, in that I don't practice law, but I really appreciate not only the incredible individual efforts of the people and organizations that you see in front of you, but also how it integrates into my work as an advocate. I've been spending my time in Washington, D.C., doing a lot of federal advocacy, particularly on CBP and border issues. But to really bring integrated advocacy and integrated litigation to fruition, you need collaborations of the type that we've come together in this conference to do, but of the type that I think each of our panelists will really get into in their presentations. And I wanted to talk a little at the start about what this integration means. And I see it as a spectrum, and at the ACLU we try to work when we hear about problems in immigrant communities to make sure that we address them just the way, I'll use an analogy that'll be perhaps surprising, the way CBP does. They call it the consequence delivery system. They have these charts where everyone coming across the border now is supposed to receive a consequence. And this was a response to what was called catch and release. And now everyone is supposed to, from a chart that is undoubtedly being updated nefariously by the new administration, applies various punishments depending on what your individual equities are, what your individual demerits in their view are, but also what the capacity of particular places along the border are for criminal prosecutions, for expedited removal, for voluntary returns, for various things the immigration and criminal justice system feel that migrants have to be punished with. And I would like to turn that around. I think when there are abuses in the community, we have to deliver consequences back to DHS. When ICE or CBP violates someone's due process rights, when ICE or CBP has policies that they don't live up to in sensitive locations, when ICE or CBP don't exercise the discretion that we know is the root of any proper justice system, be it criminal, civil, immigration. And so the spectrum of options one has can range just like the consequence delivery system does. One of the most extreme is to take people to federal court, but of course that takes incredible skill, effort, and a real pinnacle of a system that has other avenues to hold people to account. And what I want to explore with the panel is how litigation integrates with other methods. FOIA, for instance, which I know our panelists are very familiar with and very actively using to support various types of litigation, be it individual or impact litigation, be it administrative complaints, something we've worked on with our partners. Really, your tax money is often spent in large quantities on oversight bodies at DHS, for instance. There's a Civil Rights, Civil Liberties Office. There is an Office of Professional Responsibility that is tasked with making sure, like an internal affairs department at a police agency, that their officers and agents are not engaging in misconduct or performance problems. And then there's the Inspector General at every department in the federal government, but at DHS there's a very large Inspector General team that is supposed to respond to some of the types of abuses that can also be litigated, but this can be an avenue to test. And of course, just like you read about for police reform, there are ripple effects. It's not just the particular case that has an effect if a complaint is lodged, whether you're looking at transparency through FOIA or body-worn cameras or other types of reform. When an officer or agent has a greater than zero understanding that their misconduct will have some consequence, and that we have access to it, be it footage, be it documents, be it legal cases, then there will be not only a consequence for him or her, but there'll be a ripple effect for their colleagues in terms of how they do their jobs. And I think a lot of the accountability that you see in the federal legal cases we're about to hear about is a continuum along that spectrum. A lot of these things reinforce each other. Of course, they work together in particular issue areas that we'll hear about. But I think we have to maximize our use of all of these tactics because we know the challenge is so great and that the abuses are so numerous. So with that, I would also like to talk about the federal legal landscape in June, which is, of course, the last month of a Supreme Court term. There are going to be, as was referenced in this morning's panel, some very important cases from the Supreme Court, but there are also cases all over the country that are really ongoing. There's a lot of litigation and a lot of issues that are new in the Trump era, but there's an awful lot of continuity in terms of what was being challenged in the last administration as well. So the Rodriguez case about bond hearings is due this month, and after that argument that the professor referred to this morning, I think they asked for enormous supplemental briefing, which is very rare in the Supreme Court. Usually things are argued and briefed before that, but the court very rarely asks for additional materials. In this case, we got the ACLU and the coalition of lawyers in the case got an enormous order really challenging the very basic assumptions of immigration law. And so this could be an extremely broad decision with great impact, especially with the different administration that will implement it, or it could be a narrower decision based on the particular issues involved about bond hearings that Professor Rio mentioned this morning. And the other case, particularly relevant to my work at the border and with CBP, is called Hernandez v. Mesa, which is the cross-border shooting case where a Mexican teenager, unfortunately not an isolated incident, there have been many cross-border shooting cases and many deaths at the hands of CBP, but Sergio Hernandez Guerrica was shot across the border from Texas, and the question is what sort of liability can attach in a civil proceeding his family has brought against the agent who shot him. And so those two cases, other cases, whether that be they detainer cases that we've talked about in terms of ICE requests to state and local jails to hold people beyond their release dates in their criminal proceedings. There are cases that are ongoing in terms of federal court, but also the Supreme Court in Massachusetts and others have looked at whether their state constitutions allow this sort of unjudicially approved detention. And there is, of course, sanctuary city litigation and other things that pertain to Trump, but that build on a lot of what happened in the Obama years as well. And so, without further ado, I would like to pass it on and introduce very briefly each panelist before she or he speaks. But I wonder if we could start with Esther Sung, who's with the National Immigration Law Center and is perhaps the most pressed of all our panelists because she is involved in the IRAP litigation against the administration's Muslim ban with a deadline, I believe, of Monday.
Should I
talk about IRAP?
All right, IRAP. Yes, we're in the middle of briefing right now. Some of you may know that the Fourth Circuit affirmed the Maryland District Court's injunction of Section 2C of the Executive Order, the so-called Muslim or travel ban. Section 2C deals specifically with the suspension of entry of nationals from these 6 designated countries: Iran, Libya, Sudan, Somalia, Yemen, and Syria. We were really happy when the Fourth Circuit, in a 10-3 vote, affirmed the district court injunction. Then the the administration has filed pretty expedited briefing with the Supreme Court. They've actually filed 2 separate requests. One is for merits review. They've asked for a writ of certiorari, which I'm sure you've heard of before. And the other request was for what's called a stay of the injunction. They essentially want to lift the injunction and allow the executive order to go into effect. The Section 2C, the enjoined portion, because the rest of it already is in effect. What's unusual is that they also filed a similar stay request for the injunction that was issued by the Hawaii court. And you probably know that there's been a parallel proceeding going on in Hawaii, where another district court also enjoined certain sections of the executive order. The Hawaii court enjoined all of Section 2, which includes, as I said, the travel ban on individuals from these 6 designated countries, and also Section 6, which bans refugees from the United States for 120 days, and also reduces the total number of refugee admissions allowable for fiscal year 2017 from 110,000, which is the level set by President Obama before he left office, to 50,000. So the Hawaii injunction is broader, and it's what controls now, and it's our understanding that refugees are being, admitted to the United States under that injunction, that individuals from the 6 designated countries are being allowed, are being issued visas and are being allowed into the country. So curiously, the administration appealed Hawaii up to the 9th Circuit, as well as our injunction up to the 4th Circuit. But the 9th Circuit has not issued an opinion yet. They haven't weighed in on sort of the validity of the Hawaii injunction. But regardless of that, the government has asked the Supreme Court to stay the Hawaii injunction as well. So there are 2 groups of very frantic lawyers briefing to the Supreme Court right now. Our briefing is due next Monday. The court will probably issue a decision on the stay requests soon. We think that they can issue such a decision at any time. It does require 5 justices to vote in favor of granting the stay and allowing the executive order to go into effect. 4 justices have to vote to allow certiorari, to allow a review on the merits. And that decision will likely come out of a conference that there are only so many left in the month of June for the Supreme Court. I think they're on Fridays, but they will conference and do their Supreme Court thing and decide whether to grant cert, and then the decision on whether they will grant cert will probably be issued on a set day, along with, on the same day that they issue decisions in already pending matters, other already pending matters. Should I go into any of the actual substance of what's being argued?
I think maybe we can leave that for some of the discussion,
Okay.
if that's good. And I think if our next 2 panelists would, just as Esther has, speak briefly about their work, we'd love to engage in a discussion, which I'll lead off with a couple of guiding questions, but we really look forward to your input as well. And thank you very much, Esther. Jeff is our second panelist from University of Houston Law Center and the director of the immigration clinic there. His may be the most modest and brief bio in your packet, so I would supplement by encouraging you to visit their website, which includes the wonderful honor of the AILA Pro Bono Hero Award a couple of years ago to the clinic, which really speaks about Jeff and his team of lawyers and students' impact.
I thought Chris was going to say the honor of working for Ira Kurzman. because Chris worked for Ira Kurzman as well. So I'm gonna, first of all, let me thank CMS and STCL and Chris for being the moderator. I'm gonna talk briefly about SB4 litigation because I thought that might be appropriate for this setting. You know, I think that unfortunately we're all, you know, sort of dealing with this SB4 issue. It's going to be something here in Texas that's, as we know, going to be implemented September 1st. It's going to have, in my opinion, profound effects on the day-to-day life of immigrants here in Texas. So let me just recap the very basics of where we are in terms of litigation. There are 3 lawsuits, as far as I know. City of San Antonio, the preemptive lawsuit by Texas, state of Texas, and the city of El Cenizo. So those are 3 federal lawsuits that were brought. Obviously, the state of Texas was a preemptive lawsuit that sought under the Declaratory Judgment Act to really get the court to make a declaration that obviously SB4 was constitutional. And the fact that they did that, we can all kind of think about why they did that, and it's kind of interesting because I think it's pretty rare that a state legislature, in this case the state government, would go to court before the act is even implemented to try to get a ruling on its constitutionality. So we can talk, maybe we'll discuss a little bit about that, maybe you have some ideas. And interestingly, I'll just say another word about the preemptive lawsuit. They sued not only Travis County and various other localities, but they sued, well, I'm sorry, just Travis County and the city of Austin. They sued the Mexican American Legal Defense and Education Fund. So when I first saw that, you think, well, that's kind of strange. I've never seen a state sue a legal aid organization. Makes you think. And then, you know, I wrote a blog, and you can read my blog for more details, but I kind of came to the conclusion that maybe that's not such a bad thing. That maybe MALDEF now, because they were sued, they're a party to the litigation, that they can have an opportunity to play a part in that litigation. So maybe that's not such a bad thing. But the bottom line is, you know, if you look at the causes of action, just say briefly what the causes of action are in the various litigation, various lawsuits. The causes of actions are very truncated, I would say, in the state of Texas litigation. They only really want a ruling on 3 issues, and the first one is Fourth Amendment search and seizure, the second one is equal protection, and the third one is federal preemption. Now, federal preemption is the main issue. I think we can all agree that, you know, whether or not this state legislation is preempted by the Supremacy Clause is one of the main issues. Of course, there's other salient issues like equal protection, due process, maybe even other issues. So then I was pleased to see that in the city of San Antonio's lawsuit, they really you know, did a very, I thought, thorough job of demanding that the court address other causes of action, such as, again, Supremacy Clause. In their third cause of action, they talk about freedom of speech, which, if you know SB4, it implicates campus police, and it implicates, you know, basically any law enforcement officers, and saying that they are not prohibited from asking about the immigration status, or keeping a database, or reporting. That's basically the 3 things. And so if you really, you know, look at it very closely, that could have very, very, very dire consequences of course, across Texas and the state of Texas, but specifically because campus police are part of that specifically, explicitly stated group. And if they're empowered to ask about immigration status, as I talk about in my blog, there could be dire consequences to people's freedom of speech, freedom of association, and their ability to get an education, in higher education, in the state of Texas. They also talk about, in the San Antonio litigation, academic freedom rights. They also talk about 14th and 4th Amendment, procedural due process, substantive due process, equal protection. Then I thought they got very creative, which I was pleased to see. The contracts clause of the U.S. Constitution. So they're going to be alleging that that the contracts clause, which states that no state shall pass any law impairing the obligation of contracts, and their theory, which I thought was interesting, is that undocumented students now are impaired in their contracts that they have, either express or implied contracts with their educational institutions to get a good education. So I would like to see how the court addresses that. And then the 10th cause of action is the Section 2 of the Voting Rights Act of 1965. And they talk about SB 4's provision for the removal from office of an elected official who is found to have violated SB 4 results in denial or abridgment of the right to vote. So very interesting. I didn't, again, I wrote this blog several weeks ago, probably the day after it was signed. And so, I was just like MALDEF, LULAC, I think, is representing, let's see who's representing. No, MALDEF is representing San Antonio. I too was trying to think of causes of action, and so I really applaud them for being creative. The city of Cenizo cause of actions are a little more problematic, I would say, in terms of or not, I shouldn't say problematic, I should say a little less fleshed out, say it that way. Talking about the 10th Amendment, relating to the interplay between the 10th Amendment and 1373, which is a federal provision. They're arguing that the way that SB 4 together with 1373, the way it will be implemented would be unconstitutional. They also talk about the executive order section enforcement directive of SB 4 would be unconstitutional under the 10th Amendment, and then they have preemption. So it's not as fleshed out in terms of the lawsuit. I think the most interesting lawsuit so far is the San Antonio litigation. So I think I'll stop there and be pleased to take any questions.
Thanks very much, Jeff. Our third panelist is Andrew Free, who comes to us from Nashville. We're very grateful you're here. And I love the description of Andrew's firm. It says he's the founder and managing attorney of a social justice legal startup. And I think you'll see from his descriptions of some of his work how innovative, creative, and successful he's been in deploying areas of the law, both familiar and unfamiliar, to maximize the impact for people who've suffered abuses. And the other two things I'd highlight in his bio are a significant portion of his firm's practice involves recovering damages for U.S. citizens who have been unlawfully detained or deported. Lastly, Andrew was prescient enough to have the website www.resist.law, and I really encourage you to go there to learn more.
Thank you, Chris, and thank you to everyone who made today's event happen. It's kind of a beautiful thing to have a lot of people coming together and thinking about really important issues in creative ways. I think I'm here today to talk about our approach that doesn't focus on the traditional lanes of damages claims against federal officers and state and local officers, although we do that work. I'm going to talk today about some different types of claims that we've been bringing, and frankly a bit of a legal crusade that we've been on for the last 5 years, and we see another 10 or 15 ahead of us. But essentially, we're at my shop, we're movement lawyers. So we try to listen to our clients, who are mainly individuals and organizations, and think about what's the thing that individual or those families are most threatened by. And a lot of times the individuals can articulate it, and a lot of times by putting together aggregations of stories, we can kind of see the systems at work that are disenfranchising people or exploiting them or putting them at risk. And particularly in the immigration sphere, it's become pretty obvious what a lot of those systems of oppression are, more obvious, I would say, than at any time in recent history. And we've come to believe that one of the systems of oppression that doesn't respond to normal democratic forces is the private profit motive when it comes to immigration enforcement. We think you can explain so much of it with racism and xenophobia and nationalism, and you can explain so much of it with a desire to just scapegoat for the purpose of scapegoating and political gain. but you can also explain a lot of the resources and the reason that those democratic institutions are not accountable to grassroots leadership and movements is because we're outgunned financially. And that provides challenges, but it also, we think, offers opportunities to take back some power and shift the dialogue. If you think about August 18th, 2016, you saw the two largest private prison companies in the country lost about 40% of their value. That's billions of dollars that were lost in a single day. And that's because Sally Yates, then a DOJ official, announced that the Bureau of Prisons was going to end private prison contracts or phase them out because, in fact, they're not more efficient, they don't save costs, and they're dangerous. And the government's known that for a long time. Now, they didn't lose 100% of their value because there's still a lot of value to be had in immigration detention. And so what our clients were telling us, particularly our detained clients, is that because the profit motive is so strong, because they have to save money and maximize shareholder value, a lot of corners are cut. And one of the clearest corners that have been cut, particularly in our detained U.S. citizen cases, is in staffing the facilities. It is clear that you cannot run a private prison, a private immigration detention center, without the labor of those you're detaining. And in that way, we see a legacy of the convict lease systems that came through in Jim Crow. You see a legacy of this private-public entwinement of taking people off the streets for vagrancy or being out late or not having a job and putting them into these, basically, these vestiges of slavery, through these county sheriffs in Alabama and other places, right? It traces its history directly to that, these practices do. And so we started looking around at the law, and we decided that if you look at current law, there's a vehicle to remedy this. One vehicle is in equity, unjust enrichment. You're telling people that you can only pay them $1 a day, and yet at other places, so I should just lay some groundwork. There's some labor in private prisons that you're required to do, supposedly, and they call that the sanitation policy. And there's some labor that you can volunteer for. And for that, the privilege of volunteering to run the facility, do things like cooking, cleaning, laundry, barbershop, library, cleaning up medical, sometimes waxing floors. Detainee at Adelanto in California was killed while he was operating a jackhammer and was electrocuted. So he was working $1 a day there. But in any event, there are those systems. So there's an unjust enrichment theory, and there's also a forced labor theory. A lot of us in this room who are service providers know the Trafficking Victims Protection Act because we love U visas, right? Well, there's also a provision in there that says you can't force people to turn over their labor to you under threats of force, abuse of process, a scheme to make someone believe that if they don't perform this labor for you, then they're going to be harmed in some way. And so in what was really a Hail Mary, we sued the GEO Group, one of the two private prison companies that holds most of the beds in the District of Colorado. And miraculously, the court allowed the claims to go forward. The case was then certified as a class action, meaning we represent about 50 to 60,000 immigration detainees on various claims over the last 10 years. That case is now pending before the U.S. Court of Appeals for the 10th Circuit. But yesterday, and the day before yesterday, we got an order that is going to allow us to proceed with discovery. And some of the specific discovery we're going to be taking aims to take a deposition from David Venturella, who used to be an ICE official and is now a GEO executive. We're going to depose the warden, and we're going to continue to look at the incentives there. And I'll tell you why. This is what GEO has told the courts about this case. And this is so, like, I read this and I say, maybe we're onto something. They say, claims like these could be filed against ICE's contracting partners across the United States, creating potentially immense costs. So they say things like, essentially, if they're right, if we're right, GEO cannot function. That's what they've told the U.S. Court of Appeals for the 10th Circuit. And I was going to quote the entire language, but I don't want to run too much. I guess the last sentence I'll leave you with is, GEO faces incalculable monetary claims. So we've struck at something. We do think that these policies and practices happen in other places, even though it's a Colorado class right now. An attorney just filed in the Southern District of California against Core Civic, the other main private prison actor, and there will be more claims to come. So I'm happy to talk about it more there. I'm happy to think about like the intersection between labor groups who are being locked out of the facilities and detainees who are being locked in and forced to do the work. But I think I'll leave it there.
Thanks so much, Andrew. To kick off our discussion, I wanted to ask a bit more about this concept of integrated advocacy and litigation, how it affects your work. And a subset of that is to talk a bit about what sparks led to the cases you talked about, or in general, your organization or firm uses to connect to what's happening in the community. As you say, Andrew, listen to people affected. Esther, in terms of that chaos of the Muslim ban in January, how clients came to NILC and others. How do you integrate the litigation to other tools, and how do community members and those affected become your cases?
So for what we're calling the Muslim ban cases, community participation has been essential. So my organization, the National Immigration Law Center, was involved in the very first lawsuit, which was filed back in January when the very first executive order got signed, and there was that blow up of chaos at all of the airports. And the reason why we found out about it is because the International Refugee Assistance Project, IRAP, had clients who were coming into JFK who were being detained, and they reached out to us. And honestly, if I wish that all of you could meet the executive director of IRAP. She is a force of nature, and I'm sure you saw in the news that there were a bunch of attorneys who went out to a bunch of airports who were just sitting on the floor with their laptops plugged into outlets wherever they could, trying to assist the people who are being detained. And that was all because of this enormous community outreach effort on behalf of that IRAP undertook, and mustered up attorneys all over the country to go to their respective airports to assist individuals who are being detained under the first executive order. And we're so glad to be in the first lawsuit that we filed on behalf of two individuals who were being detained at JFK. IRAP was our co-counsel, and so it was a no-brainer that when the second executive order got signed, that they would be heavily involved in our litigation, and they're now our client. In addition to that, I mean, NILC has a communications arm, it has an advocacy arm. It's very much on the forefront of our minds that legal litigation is driven by people, and we have minds at NILC actively thinking about how do we tell the stories of the people who are affected by this executive order and who are involved in this litigation. And I think that means something. One of our plaintiffs is from Texas. I'm from Texas, and just knowing that one of our plaintiffs, I could drive up to Dallas and meet him. I mean, that really means something to me. And one of our clients in the first lawsuit that was filed, his family lives here in Houston. That has meaning to me, but I think it also has, these types of connections have meaning for all of the attorneys who are working on the litigation. And we, especially as as we're moving forward to the Supreme Court, another really important source of community engagement that we have is our amici, our friends of the court. We just have a whole slew of amici. They cross the entire range of interests and stakeholders. We have governments, local governments. We have cities and major counties in the states. We have faith-based groups. We have a whole cadre of professors of different interests. We have history professors, and and to read their briefs and to communicate with them and see the support that they have for this litigation has been really moving to me personally, and it should be moving to, I think, anybody who has a working heart, just to see how many people are energized by what they see as a constitutional violation and a condemnation of a single religion by the person who holds the highest office in this land. And I mean, I can tell you from firsthand experience that filing something in court, even if it's just one brief, not the daily grind of litigation, it's hard. There are a lot of arcane steps and boxes that you have to check just to get it accepted, your papers filed by the court, and to know that there's a group of Franciscan nuns who wants to make that happen. They want to sign on to a brief like that to make their voices heard is pretty cool. Just to point to one of our very many amici.
Thank you, Esther. So to answer Chris, I think Chris's question is how do we get clients and what types of cases? So I'll just be very brief. I think for federal court litigation, I think at least for clinics that I had, I think habeas litigation is very important. So if any of you from the community have issues, like for example, detention issues, and I was a part of, shout out to HILSC, which Vin already talked about, but the Houston Immigration and Legal Services Collaborative, and Kate and Andrea are here, and they deserve a lot of credit because when the travel ban came along, they were the ones on the front line. They were the ones calling attorneys, getting attorneys. Rosemary Vega, who's here today, she was the one who called me up and said, "Hey Jeff, let's go down to the Houston airport. We have somebody. I just got a phone call. Meet me there at 12." And I was there, and we spent a long time, there that first weekend. And so Rosemary deserves a lot of credit. So anyway, we've mobilized here in Houston. Habeas, of course, mandamus, I think also has a place, and so without going into all the details what that is, but if you have clients or people in the community who have been pending their immigration processes for more than a year or sometimes even years, then that is a process in federal court. You can go and ask the judge for a writ of mandamus. And basically what it is you're trying to get the federal judge to order the agency, usually it's USCIS or another agency, to do something they're statutorily mandated to do and to make a decision. Maybe not approve it, maybe it's denial, but you want to get a decision. So again, that's another habeas than mandamus. We're involved right now at the UH clinic with a Hague adoption or Hague abduction case representing a little girl and a family member where somebody is trying to bring her back to her country when she's already pending asylum. So again, that's a federal court matter. These people would not have representation but for Catholic Charities and for us. And then the other litigation is like Andrew's, and I know Chris has been involved, and ACLU, of course, has been involved. And these are more like wide-scale challenges to the policies or practices, I would call it, or class actions, or suing private prison companies, et cetera. So those are, and of course, there's many more different types of federal court litigation impacting immigrants. Bob Powell, if you're interested, Robert Powell wrote a book on it. I forget the name of the book, but it's federal litigation involving immigration, so you can look that up. But how do we get cases? From you guys, from the community, from Catholic Charities, from YMCA, from other organizations, primarily contacting us and saying, hey, can you help on some major issue? So that's how we get clients.
I think I don't think I can say more about like where they come from, but I think I could say more about like what's a case and how do you put that together. As attorneys, I think it's incumbent upon us. So everybody's doing this work. I think you guys could all be different places. Everybody's doing this work because you care about the world. You want to have an impact in real people's lives, and in some way you want to use your skill, talent, and training to make something better, which is not what a lot of our colleagues in the bar can say. If you think about what a lot of our colleagues do, or if you're a community organizer, you're doing that for similar reasons. A lot of your colleagues, that's not what they do during the day, okay? So if we do that, then we also have to do like a little bit of a privilege check, and we have to think about the way we think about litigation and lawsuits and the law. We are taught like there's two sides of the V. There's like a winner and there's a loser, and then there's a legal outcome, and that's what we're focused on. That's how we're trained. When in fact, what I've learned from people that I've represented is that there's a ton more going on there, and most of it's about litigation and cases as being a means to address a problem. It's like a vehicle. It's not the end. It's not the thing that you're doing. We don't file a suit to file a suit. You file a suit to address a problem. And so in order to do that, you have to hear people saying what the problem is. You have to be astute about what tools are there. And I would say particularly in Texas, particularly in this moment, whether it's your immigration courts or your federal district courts or your state courts or your state government, we as attorneys need to step back from the thinking of there's like a win-loss outcome and oh no, if we lose. There's a value to creating space, to creating room to have a fight that you're not going to be in control of, that people in motion are going to be in control of. The fact that at the Fourth Circuit, the Court of Appeals, when they did the oral argument, it was full outside. Like it was full of people who just came to hear. And the same thing on, in other Iraq cases and other Muslim ban cases. If you look at the airports, like we're using our skill as like a tool to make that change. And so I guess when you're thinking about what is a case, the question is, well, where's the fight, and how can we use these means, these like arrows in the quiver to help that fight? I mean, I guess that's the only thing I would add to what they've said.
Thank you all. I'd definitely like to invite people up to the microphones for any questions or comments, and we can continue, please.
This morning I heard about 287G and how it relates to SB4, I think. A month ago, our daughter was stopped for a traffic ticket, given a warning. In the process, she was asked where she was born, her social security number, and on the ticket it listed, was she Hispanic, non-Hispanic, or Muslim, or Arab American, Arab, anyway. Asian. Anyway, those three were listed on there. Is that part of the 287G that Comal County is allowed to do right now?
So yeah, if I had more time, I would talk about 287G. I mean, I'll answer your question. 287G, the reason why it's relevant, I think, to the litigation is because the 287G, part of the INA, the Immigration Nationality Act, provides for voluntary agreements called MOAs, which are Memorandum of Agreement, between localities and the federal government. So that's part of the INA already. And what people forget is that the 287G program also provides for two things: training of state officers, they have to go through training, and they have oversight of those state officers. So yes, we have delegation of authority from the federal government to state officers already in the INA. SB4 is trampling 287G because it's basically saying that those state officers, all bets are off, all constraints are off, they can go ahead and ask about immigration and enforce the full panoply of immigration laws, but without any training, without any oversight. And I think that's the real problem, and you've put your finger on one of the central arguments in the preemption cause of action.
Thank you. John?
I understand that there are two cases of litigation going forth. One has to do with, in the federal court, with due process regarding litigation or processing of immigrants. There's some sort of federal case challenging the lack of due process, and the other has to do with the limitation on that the courts have imposed on private contract prisons for time in which people could be held. There was a case on that, and where is that these days? Because it seems like that's no longer in effect.
So due process is definitely the root of a lot of this litigation, in terms of describing everything from an asylum seeker's opportunity to make his or her case at the border to the bond hearings that we've been discussing. This is something that talks about what the government needs to provide and what it has said it will provide. So a lot of these cases, I think, are perceived at times to be asking for more, but they in fact ask for just what the government is saying that its policy is. And so, be it in any of these examples, the Due Process Clause of the Constitution holds the government to a certain minimum, but also requires it to adhere to what it's said that it will do. And I think a lot of what the abuses stem from are efforts by DHS personnel to put their own policy preferences in place of government policy. And I think that's an enormous concern. When Esther's describing the chaos of the first Muslim ban, there were CBP officers denying access to counsel. There were CBP officers denying members of Congress who were at the airports the opportunity to see what was going on. And I think this era is so difficult in many ways, and of course, not for the lawyers, but for the people who are experiencing it. The spotlight that is placed on immigration detention or the asylum process or what CBP claims it can do at an airport in secondary inspection is going to have an enduring effect. People aren't going to forget, either certainly in terms of the incredible court record already in these months, but in terms of the stories that are coming out because of community efforts not to let things go. And there was always an effort to litigate immigration cases, but now, as I think previous panels have talked about, this is at the center of the progressive vision of what the Trump administration is trying to change and destroy, which is individual rights, in particular of vulnerable communities and communities of color. So I think the Due Process Clause is at the heart of that, and I wonder if Andrew would talk a bit about the detention side.
Well, I was just going to add that I think the speaker or the gentleman was asking about the Jennings case, and so there is a case that is currently pending in the Supreme Court, and so we should see that decision this summer. And that's on whether you need a bond hearing after 6 months, and the Ninth Circuit already has a rule that you do need the courts, immigration courts have to adjudicate whether or not somebody's a flight risk. Unfortunately, that's only in the Ninth Circuit. So we'll see what the Supreme Court does. I think this summer we're going to see several, maybe a handful of really, really, really important immigration cases. So I would stay tuned.
First of all, thank you all for your work. I mean, it's just so incredibly important. I have two questions. One for you, Andrew, which is if you could talk a little bit about the size, the power, and the legislative reach of the for-profit prison industry. I mean, it seems to me that what's happening right now is that you have this government-funded lobby that's got a solution to every immigration situation, and it's to create more enforcement infrastructure and harsher laws. And that's happening at a time when, like the other government-funded network, which is the Refugee Resettlement Network, which has always been pro-refugees, pro-immigrants, is being depleted, So if you could talk about that. And then I have a second question, which is this issue of you have people here who run shelters in Mexico, and they see all the time people turned away who have requested asylum or expressed a fear of persecution. And I mean, there's violations of those laws even in front of groups that are sent down to monitor them. And it's even announced occasionally by CBP that we're just not taking those cases in across this port at this point. So is there kind of a litigation plan strategy? Is anybody looking into that?
So with respect to the scope and power of the private prison, the prison industrial complex, it's a pretty unique thing in our country's history that we would cede so much control over policy to basically unaccountable, over policy about who's going to be free and who's not. I mean, that's kind of what we're talking about here. In Texas, you guys had a private prison company try and write a bill. They just admitted, the people who introduced it in the legislature just admitted, GEO wrote this to license family baby jails here in Texas, right? It failed because they were busy, screwing everybody as opposed to just women and children seeking asylum. But this is, I guess what I would say is these are very sophisticated, multi-billion-dollar corporate entities. They're structured as real estate investment trusts, which makes them super duper profitable. In other words, they say they are in the business of owning and disposing of real estate. But if you think about what they actually do, it sounds a lot like the Virginia slave codes. I mean, if you think about what they're actually in the business of and the fact that if people aren't on that real estate, there is no value to it, it's very clear what they're actually in the business of. But they have an industry capture. SB 1070 in Arizona was drafted in large part by the Corrections Corporation of America through ALEC, the American Legislative Exchange Council, where they get together and they invite legislators to come and file bills. And then there were copycats in Alabama, HB 56, in Georgia, that NILC, thank goodness, and others, ACLU, and a lot of other incredible people, some of whom are probably in this room, successfully fought back for the most part. But we have a raft of state and local initiatives pushed by private prisons and the private prison industry in both, and it's not just in immigration detention, it's in the criminal justice space, it's in alternatives to detention now. They've kind of figured out, or they had, that the jig was almost up on mass incarceration. They had seen the curve, I believe between 2010 and 2015, America's incarceration population went down 8%. Crime went down 15%, which was nice. And they had kind of figured out we want to do alternatives to detention. So they started buying up ankle monitor companies. And now they have a really great vertical integration so that if you violate your terms of your release, they can violate you to ICE and get you put back into their private prison detention. So they're actually edging out some of LIRS. The Lutheran Immigrant Refugee Service had a bid out to do a community monitoring program for people who got out of immigration detention. Because 95% of people who are out and have a lawyer and have a community support network show up for their hearings. And instead, that contract went to GEO, the GEO group, in some sort of fake community organization. So basically, they buy off the former agency officials. They come out of this revolving door, and then they get contracts. And using those contracts, they give kickbacks. And here we are. Their stock has fully recovered under the current administration. And so when we think about how to fight this, I think we have to learn the lessons of corporate campaigns. Because believe it or not, corporations actually are responsive to stigma. These corporations are less responsive because of the business they're in. But Nashville, where I practice, is the home to the Core Civic, formerly the Corrections Corporation of America. And actually, I don't call it Core Civic because Civic is a visitation group based out of California, and they're in a trademark fight over their name, right? So anyway, I think the scope and power is unprecedented. It has grown. We've seen from 2011 to today, they want to grow the detention bed number from 34,000 to 51,000. They want $7.5 billion more to do this. In terms of fighting back, I think we have to learn those lessons about how do you hold corporations accountable. And I'll let the other question flow this way.
On the second part of Don's question, I know ACLU has done some great work on conditions at the border. There are also cases, Supreme Court cases, that say there's a right to apply for asylum. So to the extent that the CVP is violating those Supreme Court cases, then I think somebody would have a viable claim. I think the big problem, though, with bringing that type of litigation is standing and finding plaintiffs, because we've had a lot of difficulty even in the IRAP in the Hawaii case, the Ninth Circuit case, with standing issues, and so people have figured out ways in the IRAP litigation, for example, to argue for third-party standing, But technically, or some people say that there's no extraterritorial application of constitutional principles, and so you would need some way to be able to bring a case like that in terms of a third party standing, arguing that their rights were violated, even though the person's still outside of the country. And that's the and you guys can chime in, but that's my take on the difficulty of those type of cases.
No, that's absolutely right. Standing is the big problem. The way that we've addressed it in IRAP is our argument is that the rights we're vindicating are the rights of the United States citizens and residents who are here in the country, who have filed petitions for visas on behalf of their loved ones who are abroad. And apart from the Establishment Clause and sort of religion-related claims, the sort of equal protection claim is that if you're a refugee, or if you're a person who harkens from one of these designated countries, your petition for your loved one is treated differently than someone else who is from Canada and petitioning for their loved one to come from Canada or from any other country apart from the 6 designated countries. And so those are the rights that we are attempting to assert here. And it's much harder when it comes to asylum cases, when someone is just coming to the border, especially if it's someone who doesn't have any ties to the United States and just is presenting themselves. Standing is the really big problem. And we see the very first thing that the government has done in IRAP and in Hawaii and all of these cases is to attack us on standing.
You also have Grupo Beta on the Mexican side, essentially giving out tickets and saying you got to go to this shelter before you can come to the U.S.-Mexico border and present your claim. So there's and the CBP officers basically deferring to enforcers on the Mexican side. I mean, this is, to me, it's an outgrowth of this great ACLU visual. It's a map. You can just Google ACLU Constitution-free zone, and it'll show you the places in America where, according to various court rulings and doctrines, we have this watered-down constitution. And when you start limiting, and it's basically the border. We're 100 miles from the border, or around an international airport. And we think it's, if they're on a train, or maybe if they're coming from 100 miles of the border, and it's just kind of clept all of Florida, the entire Gulf Coast, most of Texas, right? And it's basically this seepage of illegality and of ceding in the name of security and sovereignty these fundamental protections that we've built in. That's how you get to a position where you have a statute, you have an international obligation, and we're not going to honor it because these individual officers know that there's not going to be any accountability if they don't. And in fact, the U.S. Court of Appeals for the Third Circuit just held, and was upheld by the Supreme Court, just held that if you are a woman or a child asylum seeker who's been put in expedited removal proceedings, maybe the first people in a long time since the Magna Carta, you don't have a right to a habeas remedy. You think about the Guantanamo Bay prisoners had a right to a habeas remedy, and yet these women and children have been detained in Pennsylvania after being detained here in Texas. They've been detained in some of them 480 days, can't challenge the basis of their detention in a federal court, and that was upheld. So it's like a seepage of this illegality. It's an outgrowth.
And definitely on the asylum denials and discouragement, I would highlight the work of groups in El Paso who brought this to the fore, but especially Human Rights First recently has published, and I know is on the 9th floor here, some remarkable qualitative work on the extent to which people are being denied their process. Process. The outcome is something that is difficult enough to achieve. I heard yesterday that Houston Asylum Office, for instance, for credible fear, passes people at a rate of 22%. But these are people who aren't even getting the credible fear interviews, and I really encourage people to read the Human Rights First and El Paso-based groups' reports. Whether litigation is the answer here, It's again, I think, back to some of what I spoke about in the beginning, which is we have to do, as Kathy Doan was saying earlier, we all have to pass the baton of information to each other, because it's either the spark for a lawsuit, or it's the impetus for an administrative complaint, or it goes to a member of Congress's office. And something has to be done. It may not be satisfying in outcome, it may not even be a transparent process, but something is done with these complaints. And I've been in too many meetings where there's a little chart by the government oversight component saying, oh, we got 10% fewer complaints this fiscal year, things must be getting better. And I completely understand the demands on, of course, attorneys, but even more organizers and individuals. It takes a lot of courage to come forward, especially if you're a repeat border crosser, for instance, for work, who's being abused, or someone who's worried about their family. But I really think if we pass the information to each other, even at a very skeletal level, I mean, the briefs that my colleagues produce here are of the most incredible depth and quality. But the complaint that you have to send to DHS is basically a name, rank, and serial number, a time of day, and what happened. Put the burden on them to develop that. They are the ones who have to look into this case and account to you as the complainant and us as organizations for what happened. And I have really thought that this is our opportunity right now to take advantage of members of Congress going to airports, you know? That's not something that happens every day. Members of Congress who care about the fact that these ICE raids are not targeted, you know, that they're dragnet operations. And this sort of transparency, be it through the Freedom of Information Act or complaints or other means of bringing this to light, I think it's all part of a larger effort that litigation is often an integral part of, but is not the only avenue. And I wanted to just pick up a bit on what Andrew said about the Third Circuit, because I went to that argument in Pittsburgh, and it was one of the most discouraging cases, because as Andrew says, it was completely out of step with centuries, literally centuries of law in terms of the right to challenge your detention. And it was so clear that the unfortunately unanimous panel, although some judges dissented at the en banc stage, they were concerned about the policy implications. Would there be tens of thousands of cases of people asserting their constitutional rights? And of course, too much justice is not a very good argument to deny these constitutional, well-founded claims. But I wanted to ask, and we had touched on it briefly before as a panel, but the ACLU, of course, above all, has been stressing "see you in court" as the theme for this type of era, which is already feeling like years, but has been months in terms of Trump. How much, or too much, emphasis are we placing on judicial remedies, especially as the Trump administration starts appointing federal judges, especially as we emphasize in a David v. Goliath way that there are 10,000 lawyers in the Department of Justice. There have been incredibly courageous judges, and Andrew's Geo Group case, I think, shows the power of a district judge when a corporation is flouting legal process. The Fourth Circuit, the opening paragraphs, as I think were mentioned in another paragraph, are ringing and will last for generations in terms of separation of powers and the judicial role. But are we putting too much emphasis on the courts in all this?
She's got a brief due one day.
I mean, it's possible, yes. And unfortunately, the reason why I say that, the first thing that has come into my mind is that, I mean, very much intimately tied with the executive order, this Muslim and refugee ban. Our fear is that even if we prevail at the Supreme Court, the Trump administration can still effectuate the same policies simply by, and it's already taking steps. You know, it's implemented this extreme vetting where certain individuals from certain countries have to provide 15 years of travel and employment and residential history and 5 years of social media handles and things like that. And we are afraid that the Trump administration can essentially achieve the same policy goals of excluding people from Muslim majority countries without the literal text of an executive order saying that that's what they're doing, and that is much harder to combat. We're thinking about how we can do that, but you can't. There's no express presidential proclamation saying this is what I'm doing that you can target and fight. And so yes, like sometimes litigation isn't always the answer. I don't have another answer to how we would combat something like extreme vetting or policy changes that are far less transparent. But on the flip side, I think yes, like there are many other avenues to affect change. Advocacy, just even in NILC, we have a litigation group. Like I said, we have a communications group and an advocacy group too, and they are engaging with sort of the narrative and the heightened attention that immigration issues are getting, both in the general public sphere, but also in the political sphere in DC. We're engaging with members of Congress a lot more than I think that we previously had, because people care about these issues. So I agree that yes, litigation isn't always the answer. It's a useful tool, but one of many.
I'll be very brief. Federal litigation is underused, in my opinion. We need to file more federal litigation. I'm going to be very clear. Ryed is a great litigator, and the bottom line is that's what the federal courts are there for. Okay, that's what they're there for. And I'm so proud. I want to say this public. Of course, I'm speaking on my behalf, not the institution, not official capacity, et cetera, et cetera. I'm so proud of the Fourth Circuit and the Ninth Circuit, and I'm so proud of the district judge in Hawaii and the district judge in Washington. And if you read their decisions, I mean, it really makes you emotional to read those decisions, because that's the backstop for our Constitution, the federal courts.
Yeah, I think that we're dealing with a group, or we're dealing with systems that are generally not challenged. Most ICE agents have never been to a courtroom. They don't know how to testify. Most CBP officers will never see a judge. And the first time you pop up with a lawsuit, first time you put some abusive sheriff or sheriff's deputy in court, you see an immediate change in the way they start going about their business. We sued a fugitive operations team about five times in Nashville, and all those agents left. And we don't have a fugitive operations team in Nashville now. They're going to bring one back, I'm sure. One of the favorite outcomes I've ever had was a case we lost spectacularly. The Tennessee Supreme Court overturned 50 years of law and ruled against us. We thought we were right. It was the 287G program. We challenged it. We had sound strategy, and we ended up losing the case. Before we lost the case, the sheriff abandoned the program, and what he cited was the controversy surrounding it. And the reason there was controversy is because on the day of the Supreme Court argument, there was a march of thousands of people in Nashville, immigrants, union members, church people, from a Presbyterian church to the plaza outside the Supreme Court. And the argument was interrupted by people outside chanting, "You have to end this." And so while, that's a bad legal outcome, I wish we'd been on the other side of that. But 287G went away. And it went from about 10,000 deportations in several years to about 500 a year out of Nashville. I don't think that there's yes, we are going to lose in court. We're going to lose in court. And courts are not a panacea. And sometimes winning in court feels worse, because then the case is kind of over. There's something just not satisfying about a good settlement or a good judgment, because you haven't gotten everything you want. But I do think that if we're not using it, if we're not going to one of the only places we have left is a forum where we can maybe get a fair fight, or at the very least we can have the ability to fight on an even playing field, we're giving up a huge amount of power for the people we're working with and representing. Like corporate interests aren't afraid to go to court. They clog up the dockets. It's most of the court's business is pro se prisoner litigation and corporations fighting over money. So let's bring more cases.
And immigration,
Right.
immigration enforcement against,
Yeah. Right.
against immigrants. That's another clogging up the docket.
Great. Well, I'd really like to thank the panelists. That was an excellent discussion and very much appreciate it.